state and I agreed to a stay because it didn't make a whole lot of sense to litigate a motion to dismiss down below when we're on appeal on the most important issue, which is the issue of liberty. And the appellate court's decision on that would greatly affect the case below. So we stayed the case below, we appealed to the Third Circuit. So now that the Third Circuit has dismissed the appeal as moot, it goes back down to the district court. And the Third Circuit said in its order that they're making no comment, they have no judgment on whether or not the case is moot. Cesny v. Murphy, I do not think can become moot. I think that it's protected against mootness, the case itself, because we've pled damages. It's a 1983 action. It's not as strong as the 1983 protection that we have in Gottschall Right, because in Cesny v. Murphy, the constitutional right that we're alleging was violated is the constitutional right to liberty, to refuse medical treatments. Whereas in Gottschall Right v. Murphy, it's the right to be free from unreasonable search and seizure under the Fourth Amendment. And there's like this whole body of case law that is already in that area. Whereas in the area of the 14th Amendment, we're dealing with Jacobson. So the issue is that when you are prosecuting not prosecuting, but putting forward a 1983 action, the defendant raises the defense of affirmative immunity, saying that, affirmative defense of qualified immunity, which is basically like, well, we were operating in a gray area and it wasn't obvious to us that we were violating the Constitution, so we can't be held personally liable. That's essentially what it boils down to, though there's like, as there always is, there's like magical case laws and tests and stuff like that the courts will actually apply. So it's not a strong protection against mootness, but it is a protection against mootness. But more than that, in this case, the nurses lost their jobs. And so the court can provide meaningful relief simply through doing declaratory judgment, because it's the difference to the nurses as to whether they were terminated from their jobs for insubordination, as their employers allege, or whether they were terminated from their jobs for standing up for the constitutional rights. So the issue with mootness is that a case becomes moot if the court cannot provide any meaningful relief. So in Cesny v. Murphy, basically the case itself, we're saying the meaningful relief is a declaration and recognition that their constitutional rights were violated. And the reason it's especially important in this case is because they lost their jobs. So I think that goes a really long way toward protecting the actual case from mootness. The question was the appeal. And when the Third Circuit first said that they were going to dismiss the appeal as moot, I thought, okay, so we'll go back down to the district court, we'll litigate this motion to dismiss, and then we'll be back up on all the substantive issues and also the issue of mootness, because I'm sure the state will raise it below. And so that was what I was going to do. But then the next day, one of you, somebody on one of my lists, emailed me I don't know if I'd call it, I guess a memo. It was a memo from the New Jersey Department of Health saying that the vaccine mandate had been lifted, but quote unquote, they reserved the right to put it back into place at any time. So I thought the Third Circuit got it wrong dismissing the appeal for a number of reasons, but this really bothered me because one of the things that the court was supposed to determine in determining whether the appeal was moot was whether it's absolutely clear that it's not going to reoccur. That's the question that concerns mootness. It's absolutely clear that it's not going to reoccur. And I was a little annoyed because when the state wrote to the Third Circuit to say that the case is now moot, they literally just said the case is now moot. The state made no representation. We're not going to do this again. The state didn't say that. So it's hard for me to see how the court could say it's absolutely clear that it's not going to reoccur when the state itself has not said that it won't reoccur. And by the way, it's the same issue in the testing mandate case. The court said it's absolutely clear to the court that this won't recur, but the state hasn't taken that position. So I don't see how the court can. But in any event, DOH puts us out this thing the very next day saying they reserve the right. And the same day, the FDA approved the updated bivalent vaccine for the fall. And it got me thinking that maybe I ought to appeal it now or petition to the Supreme Court. So what we would do is I would write a petition to the Supreme Court saying, please hear this. And my initial thinking, and still my thinking, is that it's unlikely to be granted because the question of an appeal is moot versus a case is moot is different. And so I think there might be more deference to the Third Circuit here in dismissing the appeal as moot. However, as I survey the general landscape of the cases that remain, I don't think there's that many mandate cases remaining. That's the first thing. because there's no mandates anymore, there's not going to be any new cases brought. There'll be cases brought for employment cases, but those cases don't address the issue of liberty in the Constitution. So the pot of cases that are still there, they're it. One of those has to go to the Supreme Court on the question of liberty. They're all that's standing. And I'm just not sure how many there are. So my thinking, and what I'm telling other attorneys who have cases that could go up is, go for it. Like, we have to get a case up there. So I think every case needs to be appealed. Then I realized I wasn't really following my own advice, because if I'm telling that to people, then I should probably try it as well. So that is something I'm thinking about, whether to try to get that out there now. The other reason that I think it's important is because I have a feeling that these mandates are going to be coming back, not necessarily as executive actions, but as legislative actions. And I'm concerned that because this was done by the executive and was basically upheld by the courts because no court said they couldn't do it, that when it's then done by the legislative, it's going to, number one, knock out any arguments that could have been made concerning non-delegation, basically saying that that's too complicated to explain quickly, so I'm not going to dive into that. But basically that they're taking this infrastructure that was created through the executive orders during the state of emergency, quote unquote, state of emergency, and they're going to legitimize it by passing it through the legislature and putting it into statute, which is much, much, much harder to challenge. So my thinking is that if this is what is looking to be done, then it does kind of make it very important to challenge these mandates as quickly as possible to get a resolution on this. And so I am thinking that I will probably go up on that issue. The other thing is there might be a new wave of mandates that come, but they would be a different shot. And so I think that the state would argue that we need to like restart the litigation all over again. And when I look at the time that it took to get up there, we filed in April 2022, fully briefed in the Third Circuit by November, and then June, we still didn't have a decision. If Murphy did it again, then there's no way that we'd be able to stop it by the time we got up there. So as I'm speaking to you, I've convinced myself I'm obviously definitely going to at least take the shot. I think we have to. The other thing that I wanted to mention, which is sort of like apropos of nothing, but I wanted to vent a little bit, is when I was writing the motion, actually, no, that was Smith v. Biden. So I'll get to that in a second. So that was Cesny v. Murphy. That's where we are. That's where we're going. If I petition for cert and ask the Supreme Court to review the Third Circuit's dismissal of this as moot and also review whether they should have granted the preliminary injunction, and it's denied, I'll still get one more bite at the apple when it goes back up on the merits. So there's not a whole lot to lose there, I think. Okay, and now the last case. This is the most complicated one at this point, and this is Smith v. Biden. So I'll give you the quick timeline on Smith v. Biden. Smith v. Biden challenges President Biden's executive orders implementing the federal employee mandate and the federal contractor mandate. This case was filed very quickly. We filed it in October 2021, moved for a preliminary injunction right away. And it was Judge O'Hearn was our judge in that case, and she set a very aggressive briefing schedule. I had a brief due on a Saturday, very aggressive briefing schedule. She got us in there right away because she wanted to make the decision on November 8th, which was the day originally that the federal government said it was going to start firing people if they didn't take the shot. So she denied our preliminary injunction on November 8th. We appealed November 10th. Once we got into the Third Circuit, I made a motion to expedite the briefing because it was an emergency. We were trying to get a ruling right away. So I made a motion to expedite the briefing and it was granted. So we wrote the briefs really quickly, which kind of annoys me now because I look back on it and I'm like, well, if I could have had like my full 30 days, it would have been a much better brief. But, you know, the idea was we just needed to get it up there before the court. It's still a good brief, but in any event. Oh, my computer screen went off. I haven't seen any comments in a while, so hopefully you guys can still hear me. Okay, so let me hop back over here. I lost my train of thought. Okay, so I totally lost my train of thought. Give me 1 second to get back on my thing here. So we did the motion to expedite the briefing, briefed it really fast, fully briefed by mid-December 2021. So this case, that means I filed my opening brief, they filed their opposition, and I filed my reply. They were all done by mid-December 2021, and it has been sitting there in the Third Circuit since then. So as of this month, it's 18 months that it's been sitting in the Third Circuit. It's been 19 months since 19 months, 20 months maybe since the litigation was initiated. It's been a long time. And once again, just like it says Cesny v. Murphy, we're up there on the denial of a preliminary injunction. We're not up there on the motion to dismiss. So the motion that we were up there on was technically an emergency motion. In any event, so that's where we are. On May 17th, the federal government moved to dismiss as moot, and they wrote a motion. I have to say, just as like a side thing, over the last 2 years, I've litigated against attorneys that I've never litigated against before, those types of attorneys, because usually, like in New Jersey, I'm litigating against some large firms, but mostly like medium-sized firms, small firms, just regular state attorneys. In these cases, both in the employment cases and in the government mandate cases, I'm arguing against government attorneys, and with the employer mandate cases, it's a lot of like really big law firms, very different types of attorneys. And one of the things that I think is interesting is that I haven't been very impressed by them. I haven't thought that they were like really great attorneys, but I will say that the federal government attorneys are really good. They write good briefs. I don't agree with them. I don't agree with their positions, but clearly the best attorneys out there of all the ones that I've had to brief against in the last 2 years. In any event, so on May 17th, the federal government moved to dismiss as moot. May 30th, I filed my opposition. June 6th, they filed their reply. Also notice, by the way, that the motion to dismiss as moot in Smith v. Biden was done by motion. So they made the motion, I had my time to reply, and then they had their time to reply, and then the court rules. But in Cesny v. Murphy, they gave me a day to reply. The state didn't brief it at all. They just wrote a letter, and then they dismissed it as moot. It wasn't done by motion, and I think that's because it was sort of rushed because one of the judges in the panel was retiring. So we are fully briefed on that motion to dismiss as moot in Smith v. Biden. There was a case in the Ninth Circuit with attorney Pete Serrano, similar case. His was dismissed as moot last week, I think. I reached out to him. I'm encouraging him to appeal. I hope that he will. So I don't know. I expect the ruling to come down any day. I am going to just go through real quick some of the arguments that I made in Smith v. Biden that it's not moot. And Smith v. Biden is different because if they dismiss the appeal as moot, we will go back down to the district court, but there's nothing different there. In Cesny v. Murphy, the complaint has a bunch of causes of action that I didn't include in the preliminary injunction. So there's other claims down there that still have to be litigated. In Smith v. Biden, the only claim is liberty. That's the only claim. So if the Third Circuit says that the appeal is moot because it was withdrawn, then the case is also going to be moot. So I feel like it's procedurally a little different. I'm definitely going to appeal if they dismiss the appeal as moot in Smith v. Biden, because that basically does end the case. However, I do not think it's moot. So I'm going to go into, I'm not going to I didn't prepare a PowerPoint or anything like that, but I'm just going to sort of point the arguments, which I think are very good arguments. And to the extent there are other cases out here where attorneys are facing similar motions, I hope that they'll take the arguments and use them if they are applicable. So I have my 2 screens set up here this week because I have 2 appellate briefs too, which means I have to create appendices. It's a very time-intensive process, and having 2 screens helps. It makes me feel very with my 2 screens. All right. Smith v. Biden. Oh, no, it's not reply. So much paper in these. Okay, motion to dismiss. All right. So the arguments against mootness in Smith v. Biden are, number one, there's still an active case or controversy. So nobody in Smith v. Biden lost their jobs. Nobody in the federal government, as far as I know, other than the military, and probably healthcare institutions. But nobody, like white-collar workers, weren't losing their jobs because of the federal employee mandate, because what the government did was they put the mandate in and they maximized this period of coercion for like 3 or 4 weeks where it was total chaos and nobody knew what to do. And then the day that they said they were going to fire people after they'd pressed this maximum coercion on people, they said, oh, we're not really going to discipline people. So nobody ever actually suffered any sort of adverse employment action. So theoretically, what the government's arguing is that the fact that they rescinded the mandates basically made it all go away. There's no injury, is basically the argument. So my counter to that is a couple of things. Number one, the coercion itself is the injury, which has been our position all along. The fact that this period of coercion happened is an injury. Now, the question then becomes with mootness is, if assuming that coercion is an injury, like let's say that the court accepts that, how does the court provide meaningful relief? And the meaningful relief that we're seeking is just a declaratory judgment. However, in addition to that, once the federal government, once President Biden put that mandate in place and it started to be enforced within the federal agencies, employees started writing letters to the government about their personal religious beliefs so that they could be excused from taking the shots. People started writing letters to the government about their medical conditions that they believed made the shot dangerous for them because of disabilities under the ADA. So there was all of this private information that was taken from these employees that should not have been taken, and it violated their privacy. So one of the things that I argue is that there's this ongoing issue that the government has their private information that they should not have had to give to the government, and the employees need to know how they can be restored to their privacy. And there is a Supreme Court case that talks about that. It was it's actually a Church of Scientology case, but basically what happened was that tax returns or something got turned over when they shouldn't have been, and the Supreme Court said, well, you know, we can't undo it, but it is meaningful relief to try to restore someone to their privacy. So I used that case in that argument. In addition to that, particularly with the procurement mandate, pursuant to the contractor mandate, what the federal government did was it said every federal agency that has contracts with anyone, you have to insert a clause into your contract whereby the entity with whom you're contracting agrees to enforce guidelines that are implemented by the task force workforce task force, I don't know, some stupid government thing. And anyway, so this clause now is in who knows how many contracts. It's in the prime contracts, it's in the subcontracts. It has to go in every single contract, no matter what level, down to materials. Materials is not included. But so this clause now is in all these contracts. So Biden rescinded the executive order, but the task force still exists. And so with the stroke of a pen, whether it's executive order or perhaps some other authority, they could reenact the mandate and those contract clauses would kick in. So that's my other argument, that it can't be moot as to them for that reason. And that it would be meaningful relief to declare that it was put in there as an unconstitutional condition of employment to ensure that it's null and void. We talk about the fact that there is an ongoing constitutional controversy. The workers say that the power to decide what goes into their bodies lays with them, and the government says it lays with the federal government. And so that's an active controversy, and it's a very important controversy because it involves the bodies of individuals. So I argue that that's an active and ongoing controversy, and that the court needs to resolve that question, and also the level of scrutiny, excuse me, rational basis or strict scrutiny that would apply to these mandates. I know, like, a really long time ago, I went through all of these cases in detail, and I would like to put those videos up points on Zoom, but they have to be edited. But one of the things that I want to point out with regard to the federal mandate is that mandate is particularly pernicious because there's no authority for President Biden to have instituted those mandates at all. And that's really the problem here. For the contractor mandate, he cites a procurement law that's clearly inapplicable. It has nothing to do with allowing the president to order people to undergo medical procedures. It is a frivolous argument. And the government hasn't even really argued it. I put it in my brief that there's no authority here. They don't even cite the part of the statute where it supposedly comes from, and the government just doesn't even address it. So that's one of the things, is that the federal government doesn't have the power at all through the statute. But in addition to that, so that's a non-delegation, right? So the argument would be, and I did not make this argument because I do not believe in this argument. So the argument would be that the president says he can institute this vaccine mandate because Congress gave him the authority through the procurement. That would be a non-delegation argument. We would say, no. The procurement clause doesn't actually give the president that authority. Non-delegation wasn't delegated. It can't be delegated. The problem with that is it assumes that Congress has the authority. I don't think Congress has that authority. Vaccination and public health clearly falls within the police power of the state. It is excluded from the federal government's power, and the Supreme Court has been very clear about making sure that there is a clear demarcation between the federal government's powers, which arise mostly under the Commerce Clause, but also under a few others, and state police power, which is the federal government is excluded from. So that's another issue with these federal cases, is that it really is completely and totally ultra vires. Okay, so the reason I started talking about that, I'll just circle back now, is one of the issues that we're having in all of the mandate cases against universities, state and local governments, is they point to Jacobson. They say, oh, Jacobson is rational basis, which is, I don't agree with that, but it's not important to this point. So they say, well, Jacobson is rational basis. With regard to the lawsuits against the federal government, Jacobson is clearly irrelevant because, as I just said, the power that was upheld in Jacobson was a police power of the state, which is excluded from the federal government. So if the federal government can't point to Jacobson, like the state of New Jersey points to Jacobson, the universities point to Jacobson, the federal government can't point to Jacobson. So then the question becomes, all right, so if it's not Jacobson, what is it? And the default is the level of review that we use for every other government imposition of an unwanted medical procedure, which is strict scrutiny. So that was one of the reasons that I really like Smith v. Biden. I like the federal cases because I think that if we can establish that the federal government does not have police power, so Jacobson is inapplicable, then the next question is, to what level of scrutiny applies? The answer is already supplied by our case law, and so that would establish that, at least in the absence of Jacobson, strict scrutiny applies. And then that could then be carried over to the state mandate. So that was the order that I think would make sense for things to go, and one of the reasons I like Smith v. Biden. Just ranting about the law now. Okay, so the next argument I made is the doctrine of voluntary secession, which is basically just because the defendant stops doing something, it doesn't deprive a federal court of jurisdiction. And obviously that's what happened in this case. The federal government stopped doing something. I think the Third Circuit is analyzing the issue of mootness incorrectly on the COVID mandate cases, but there's only been a couple that have petitioned to the Supreme Court. I think there was one and it was denied. So we just need to sort of keep bringing them up. So the primary argument here is that if there is a reasonable likelihood that it's going to reoccur, then it's not moot. For the common sense reasons that we went through. If the appellate court moots it and he puts another one in place, it's going to take us another 9-10 months to get back up again. So that's why you can't just deprive a federal court of jurisdiction by stopping the activity. And that's why the court requires it to be absolutely clear that it's not going to recur. So in Smith v. Biden, it was a little offensive because they come and they go, well, it's not going to reoccur because for it to reoccur, you would have to have the exact same pandemic and the exact same shots. And if that's not going to happen, it can't happen because what's the likelihood of that? Because COVID keeps evolving. That's basically the argument. And then my argument back is that that's far too narrow. The question is not whether the exact same virus and the exact same shot. It's the question of whether the federal government has the authority to impose any medical procedure. And so I say to the court that before the court decides that it doesn't have the power to determine, or rather before the court decides that the president is unlikely to use that power again, they should first determine whether the power even exists. Because I guarantee you if they exercise it once, they'll do it again. I put that in the brief too. But one of the big arguments here as well is that President Biden, the White House put out what is it called? They put out some pamphlet, I mean, not a pamphlet, it was like a white paper called American Pandemic Preparedness, Transforming Our Capabilities, Final for Web.pdf. Basically what they said in that, this is a quote, as devastating as the COVID-19 pandemic is, there is a reasonable likelihood that another serious pandemic that may be worse than COVID will occur soon. And in that same document, they say that the goal is to be able to respond to it with a mass vaccination program within 100 days. So on the one hand, the government is saying, well, this isn't likely to reoccur. And on the other hand, they're saying this is definitely going to reoccur and we're preparing for it and we want $82 billion to go toward it. So that's obviously an issue. So I brought that up in the brief. And then we're talking about the possibility that the mandates are capable of repetition. So obviously arguing that the government is already saying the anticipated likelihood of the same or a similar situation arising in their white paper is not in front of this court. The fact that these mandates, they weren't done through a legislative process. This was in each case, in Cesny v. Murphy, in Gottschall-Wright v. Murphy, and in Smith v. Biden. In each case, the mandates were enacted and withdrawn on the single judgment of one single person. And so a law or a government action that's done on the singular judgment of one person is far more likely to be repeated than something that's done through a deliberative process through the legislature. So that's one reason that this case is more likely to be repeated than other cases and why the case should hear, the court should hear it. I argued the other thing that you have to show there is that it's capable of repetition and evading review. So I said, obviously, these COVID era cases are capable of evading review because they are. I don't want to go too hard on the court, but we've been sitting in the Third Circuit for a really long time. It wasn't. I don't think it had to evade review. I think it probably could have been decided. So, in my opinion, there's a little bit of a problem here for the judiciary because it looks like it's avoiding. It looks like it's avoiding reviewing these cases. And it's not fair to dismiss people who are trying to vindicate their rights and the government withdraws the policy and then the court says, well, sorry, but we don't really think this is capable of avoiding review, when by appearances the slowness or issues with the judicial system are one of the main reasons it avoided review. So this is, to me, this is a problem, but we'll see. And then lastly, I argue that the government is deliberately avoiding judicial review. And this is really crazy. I'm just going to read it to you because it's a little hard to understand and I wrote it out clearly here. The government took the position in this case and other challenges to the federal employee mandate that the claims were not yet ripe because the employees were required to proceed through an administrative process pursuant to the Civil Service Reform Act. So the government argued that in every federal mandate case. They said, well, I'm sorry, federal employee, not contractor. They said with regard to the federal employees, well, the federal employees are civil service employees, and so there's this bureaucratic process that they have to go through before they can sue in court. Then the government, I'll just read it. Then, after 2 months of coercing federal employees, the government suddenly announced it would not discipline employees while exemption requests were pending, thus preventing the claims from becoming ripe under the government's theory. So the government went to court and they said these people, they can't sue because there hasn't been any adverse action. And when there is, they have to sue under the Civil Service Reform Act. Then they said, we're not going to discipline one, so that the Civil Service Reform Act will never be triggered. So according to the government, not only are these capable of avoiding judicial review, it never became reviewable. According to the government, this case was never properly before the court. And this might sound like a little issue, but the Fifth Circuit case, Feds for Medical Freedom, that came up through the Fifth Circuit and resulted, I think the name of that injunction came from that case. There was I can't remember, I think it was Feds for Medical Freedom in the federal employee case. And the federal contractor came out of another case, I think, to stay on that one. But in any event, the government argued in that case, and the opinion of the Fifth Circuit revolved almost entirely around the Civil Service Reform Act. It didn't come up in my case because the judge actually sided with us on that issue below. But it's just kind of ridiculous that the government's like, basically this never became reviewable. And then I talked about how challenges to federal authority are particularly capable of avoiding review because you can't sue for damages. You can't sue the federal government for damages. You can't sue under 1983 because that's only for state and local entities. Sorry, not state and local, for local entities and local officials. There's no other way to preserve the claim. So I really think that the Third Circuit should rule on the merits in this case, not dismiss it as moot. If they do, I'm definitely going to petition to go up. I'm getting very nervous. I'm getting nervous that these cases are not going to be reviewed because the situation right now is that all through 2021, all through 2022, people sued. A lot of people sued. A lot of lawyers brought cases challenging all sorts of mandates, and they were almost all lost. There were some wins. The wins were not on the issue of liberty, though. They were like the OSHA mandate and the one in New York. Those were struck down because specific government bodies exceeded their authorities. They were struck down on authority grounds. There has not been a ruling on the issue of liberty. And I'm very concerned that we're sort of leaving the COVID era and that if we don't get this issue decided, this precedent is all going to lay dormant for a little bit. We don't know how long. It could be a couple of years. It could be 10, 15 years. But when you think about Jacobson was decided in 1905, and they resurrected it in 2021 to say that because there's this case involving the smallpox vaccine, we can force you to take this experimental gene therapy as well. If Jacobson was sufficient to force the COVID shots, then the precedent that came out of the last 2 years will be the basis for forcing anything the government wants. There's no limit. It didn't even work. Imagine if they invented another shot and they said, you have to take this shot, and you said, well, there's no evidence that it works. they can respond to the COVID shot didn't work and they were still able to force the COVID shot. That could actually, the fact that the shots didn't work could actually be turned around and used against us in 5 to 10 years. Because the government can say, look at how broad our power is. The COVID shot literally didn't work and we were still allowed to force it. The COVID shot had safety signals and we were still allowed to force it. That's the precedent that will have been set because that is in reality what happened. So I think it's really important that we get these cases out. I wanted to update you on what's going on. Let me see if I can just jump in and see if there is any questions in the chat. There's lots of questions in the chat. Okay, let me back up here. Okay. Anthony asks, is the issue of informed consent off the table somehow tied to the right to refusal? I don't know how that gets thrown out, or the idea of injury not even considered outside the big pharma-sponsored media. So the issue of informed consent is the same thing as the issue of liberty. There are two sides of the same coin. The Supreme Court actually said so. They said that the right to informed consent and the right to refuse medical treatment are two sides of the same coin. So when we make one argument, we're making the other as well. I know, the injuries. Yeah, so Murphy's been very inconsistent. It's truly ridiculous. You know, how they just rely on the CDC for everything, and it's internally contradictory. Like if you comb through the EOs, they're contradictory. Oh, one thing I wanted to mention that I did bring up in the Szczesny v. Murphy mootness, but forgot to mention earlier, is that he put in the executive order that nothing in this, repealing it, Executive Order 322, nothing in this executive order should be construed as requiring private institutions to take down whatever programs they had that they enacted pursuant to Executive Order 283. It's like, why? Just why? It just feels like it's. But if you work for a place that hasn't rescinded the COVID mandate, no, the governor actually passed an executive order basically encouraging this to continue, which was another reason it should not be considered moot. Somebody gave me a list of cases that are beating the moot arguments. I will take a look at those. Thank you. I know, it's all very confusing and outrageous. It truly is. You know, I look back on 2021 and I feel like I was so naive. I was like, oh, this violates people's rights. We'll file a couple of lawsuits. They'll be struck down. The fact that it went so completely in a different direction where there was almost no dissent. There was almost no dissent among the judicial branch of government. It's very upsetting. I don't know what happened. I don't know what happened. It's just absolutely crazy. I don't know what will happen with Rutgers next week. Well, they're going to argue it, but they're still going to have at least 30 days before they'll get an answer. If there's going to be more than one opinion, it'll be longer than that for sure. But I see no more questions. If anybody has any questions, I know there's a little bit of a delay, so I'll give it a minute. But that's it. I have a bunch of briefs I have due this week. And then I'm going to start working on the petitions. Luckily, my trial got moved. That's actually really insane. So I have a case. It's a non-COVID case. It's a construction litigation case. I'm very, very close to winning. I got everything thrown out on the other side. All I have to do is I just need the opportunity to go to trial and prove my claims. So that's been pending since January 2020. I had to reopen discovery because the defendant hid the sale of a property, blah, 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 whatever. So we're scheduled to go to trial June 26th. I'm ready to go. My client's ready to go. We're set. And I get a thing 2 weeks ago saying it's been moved to November. To November. So I called them to see if I could get it moved back, and they called me back and said, no, too bad. The trial is going to be in November. So that's not good, but it did open up a week for me. So that is good. So maybe I'll get a chance to work on some of the Supreme Court stuff. Yeah, there are lots of cases concerning the religious exemption. There are updates on that stuff too, but I can't get into it tonight. There's a lot of attorneys working on it, and we are collaborating and talking with each other. So there will certainly be news, I think, about employment stuff coming out soon. Well, thank you all so much. And I'll let you know when I have updates again. We'll see what happens, how long it'll be. But let me see if I can figure out how to end this live stream. No, I can't even. Here we go. All right. Good night, everyone.